Refusal, refusal, refusal. Such notice of immigration decision my office receives mostly every day. When we see refusals received by clients, it's very painstaking to know that their application has been refused. But that is not a stopping point. Once the application has been refused, you receive a notice of immigration decision which confirms that there's a refusal in your application. We need to then assess the next steps. And the next steps which we're going to assess can be very many. It can be either, if you have appeal rights, to go through the appeal process. If you don't have an appeal rights, there may be an administrative review rights which can be invoked. If there is no administrative review rights, we have to try to think, is there a possibility to do another application, or also a possibility to do a judicial review application? So when there are so very many options, what is the way around for the applicant and what should they take from the options available with them? Check out this video to know on what is the next steps that can be done in case your application has been refused by the UK authority. Having successfully handled numerous visa refusal cases and appeals, I understand the emotional and psychological toll it can take on individuals and their families. It's my aim to guide you through this process and provide you with some insight to help you deal with UK visa refusals effectively. So you received a notice of immigration decision, which is a refusal notice. The first step is to understand the reasons for refusal. And the reasons for refusals can be varied. It could be discrepancy in the information provided, lack of documentary evidence, missing of information that was crucial in assessing your application. Therefore, the most important aspect here is to read the refusal notice and try to understand where the gap was, where the apprehensions are, or where is it that the assessing officer is not satisfied and thinks that you don't meet the immigration requirement and hence have refused your application. Once you have understand the reasons for refusals, there can be options available for the applicant, and these options are either to apply for an appeal or an administrative review. Now, how does one decide on whether they should do an appeal or an administrative review? This decision is not to be taken by an applicant. This decision is based on the refusal notice. The notice of refusal will tell you if you have any kind of an appeal rights or an administrative review rights. It's only then you can exercise your appeal rights or an administrative review rights. If your notice of immigration decision does not inform you, then you perhaps have no rights of appeal or administrative review. It's important to note that the appeal process involves strict deadlines. So it's vital to act promptly. Hiring an experienced immigration solicitor can help you navigate the complex procedures, meet the necessary deadlines, and present your case in the most favorable light. When applying for appeals or administrative review, it is very important that you have a detailed representation for your case, including the gaps that they have highlighted when they have refused your application. But most important is to know what is the difference between an administrative review and an appeal. So an administrative review is being assigned to the same office or a manager of the same level to make a decision for the application that has been refused. However, in case of appeal, you have a separate tribunal, you have a separate judge who would be looking into your matter and trying to give you a decision here. Also, the difference between administrative review and appeal is, in case of administrative review, you're not permitted to give additional documents unless you've been refused under para 327A and B, which are country banning sessions. However, in appeal, you have opportunity to provide additional evidences which you may have failed to provide at the time of doing the initial application, and here is your chance to give them more information as well as additional documentation. The administrative review application outcome is generally been received within 4 weeks. However, the appeal proceedings is almost about a year that you get to hear from the tribunal with regards to your appeal proceedings. Remember, going through a visa refusal and appeal can be challenging and stressful time. It's essential to have a support system in place, whether it's your family, friends, or a reliable immigration solicitor. So if you or someone that you know is facing UK visa refusal and requires assistance, please feel free to reach out to Smart Move to UK team. We are here to help you, assist you, represent you, and navigate you through this difficult time. I hope you found this video informative. Please leave your thoughts in the comment box. Thank you for watching this video. Bye-bye.